Okay, the next part of our program is on updated case law in Missouri. And as you can tell, it was going to be, as I said earlier, Mike Banahan and Steve Brueggemann.
Sorry.
If either of these people look like Mike Banahan, you guys need your eyes fixed. She is much prettier, however. This is Sarah Hart.
Hello.
And Sarah's a senior associate and actually works with Mr. Banahan in the workers' compensation section in St. Louis. And Steve is a member of the firm and also practices work comp. So without further ado, I will let them speak.
Can everybody hear me okay? Is it better than the last round? I know there were some issues with hearing. Everybody okay?
Any issues with this mic? Any trouble hearing me? No problems?
During this talk, if anybody has a question, please feel free to shout out. This is an area that...
Give me time to come find you, okay? Because everybody couldn't hear the questions. So
but shout out so Nancy can come find you.
Yeah.
In past, we've done Missouri case law updates, and we've gotten some feedback. And you do have the case updates in your packets. We're not going to read through every case and go through every case individually with you. What we wanted to do is kind of give more of an overview and how it affects sort of your day-to-day, and specifically two main cases that we're going to be talking about today, and really how maybe the commission is headed. In that sense, I'm probably, Sarah and I are the bearers of bad news, but don't kill the messenger, I guess, is
There's some good news in here too, so don't be totally disheartened.
Anecdotally, I'm kind of glad that we're following the Manus discussion and the medical bills discussion, because practicing on our end, your end as well, that is something now that I think about just about with every case that comes in. It changes the way that I handle it. I'm always waiting for that elephant to poke his nose in the door and get into the room. I mean, at some point, if you have a disputed case, and that's when we come around, that elephant's going to come in and say, hey, I'm the $200,000 elephant, how are you going to deal with me? And so that becomes a problem. And anecdotally, some of the cases that I've been handling, I'll have these interesting conversations with the opposing counsel by email. And it'll usually flow like this. We provided authorized care for certain body parts, and our doctor says, listen, they don't need any more treatment. And opposing counsel says, I think they need treatment on whatever. Pick a body part above the body part that you were at. Maybe it's an elbow and now they need neck treatment. Well, the attorney says, hey, you need to have her evaluated for the neck, or you need to have her evaluated for the elbows. And I will say, our doctor doesn't find any need for that. And they will say, well, you need to send her somewhere. And if you don't send her somewhere, send me a denial letter. And so you get that. And I'm really hesitant to send these denial letters anymore, because I always want to keep my toe in the, hey, we're still providing care. And it's important. It's a subtle little thing. But and I guess my point generally is be very careful about relinquishing control of medical, especially under Manus and son of Manus. It's very, we want to keep the elephant away, and by maintaining control, that's one way to do it. And so I write back to this attorney and I say, our doctor says no additional treatment is necessary. If you have something to suggest the need for additional treatment, please by all means let me know. Then we can at least volley back and have that person evaluated somewhere else. And on some cases, I'll get the email back. It says, hey, such and such had treatment on their shoulder. Well, at least I feel better that we didn't deny care, because we weren't given the opportunity to deny care. So that's just more of a handling tip, and it really sort of dovetails out of this Manus deal, because bills get up there, and they get up there real quick, and it really changes the complexion of a file.
I think from a reserve standpoint too, when you're setting your files, we just had a case Mike and I did that we settled, and the medical was a huge part of the decision. There were also some complicated medical causation issues, but the reserves have to be set, and we had over $1.5 million, I think, in medical on this file.
So just, again, don't relinquish control too quickly. In another sort of anecdote, I got a demand filing on this file I'm trying to resolve, and part of it's permanency, part of it's the MSA, all things that we know about, and part of it was this trail along Blue Cross Blue Sheet group healthcare lien, and the client is concerned, hey, I don't want to pay that lien. Well, now you look at it a little bit differently. At first you're like, well, that was unauthorized care. Now I see that lien and I'm like, wow, that's a pretty good deal. $8,000 versus $20,000 of bill. So it does change your analysis a little bit when you're on this side, when you get these group health liens in that need to be paid. Well, would you rather pay the lien or would you rather pay the $20,000 that lien is based on? So this seminar, this portion was put together at least from comments that we generated last year. Again, it's a Missouri update on the law. The law is in your packets, but we're going to go through, and there's Mike, he's not here.
He will be here for the cocktail hour, though. He did want you guys to know that.
Yes. And please be sure to let him know how well he did today. Injury trends, some things that we've kind of dug up, things that we're seeing now, especially with an older workforce. Employer control, again, this goes to my point about maintaining control of care as long as you can. Analysis of commission trends, which is a little depressing. On to the important cases, and we start with things that as adjusters and as handlers, things that we know, or at least that we sort of accept, situations where cases aren't compensable. Coming and going from the workplace, and again, this is all stuff stemming from 2005. Extended premises, we all go the owned and controlled analysis. Some of that has changed a little bit, and that's one area where we're seeing some commission attempts at sort of reining that in. Self-inflicted injury, intoxication, rec activities, mental illness from work-related stress. That's another area where we're seeing a little bit of workup on the case law side. Assaults and horseplay, we haven't really seen anything with yet. Other reasons a case may not be compensable. First off, it says right there, injury could have occurred anywhere. And when I was looking at the presentation, I think we should have put that in quotes, because a lot of times since 2005, we hear that from clients, and they call and they say, hey, this injury could have occurred anywhere. I know he's saying it happened at work, but he goes upstairs at work. He walks on sidewalks at work. He walks on dirt clods at work or at home. That analysis isn't really right. We have to get away from that thought process because the commission is going away from that thought process. It's probably...
What's the nexus to employment?
Right, and that's really it. You have to look at the injury and go, listen, were they injured while doing something that was work-related? Don't start with, well, they could have done this at home. They could have stepped on a dirt clod at home. They could have slipped on ice at home. I mean, on and on and on.
And we're going to go through a case here in a little bit that's going to discuss that issue with more detail or in more detail.
And that's the
Young v. Boone Electrical Co-op.
Viley is a case that we're going to be talking about, and that's a case on the owned and controlled portion. Idiopathic conditions, another sort of traditional, why do you get hurt? I don't know, it must have been idiopathic. There's been one interesting case on it, and that's the Gleason file that we're going to talk about. Idiopathic is, when you look up the definition, it's due to a cause unknown.
Something that's unique to you.
Yeah, and so in 2005, when we got away from this positional risk, and we always go to the guy in the scaffolding, and he had a syncope due to a pre-existing condition or an unknown medical condition, and he falls off the scaffolding. Well, before 2005, that would have been compensable. After 2005, that wasn't compensable. And so that seems to be the idiopathic condition that we often come back to. But Gleason has an interesting spin on that, and that's something that we'll be talking about. Now, Viley versus Scholastic is sort of your standard parking lot case. And on these parking lot cases, it's a compensable injury if the injury-producing accident occurs on premises that are owned or controlled by the employer, and this additional language. But we often just focused on the owned and controlled. That's often something that I'm sure that you ask the employer, hey, I got somebody who slipped on the ice outside. Do you own the parking lot? First question. No. Do you control it in any way? No. Okay. Not compensable. Sometimes I think we often overthink this owned and controlled because a lot of injuries occur on property that aren't controlled. They occur at a construction site, or they occur when somebody's driving somewhere because it's part of their job. Non-compensable injuries occur on controlled property as well. There was a case where a guy was changing his fan belt and nipped his finger off. Well, that's not any way related to his work activity, so that's not compensable even though it happened on owned and controlled property. A lot of times these really come down to icy conditions or dirt or mud or things like that that we should have that would expose them to a higher risk. So this case kind of comes down to, and this really falls under commission trends possibly. And I'll let Sarah tell you about the case.
So this was a situation where this employer was leasing the parking area. And under the terms of the lease, the employer would exercise control over that lot. And so in this case, they'd asked for some maintenance. The employer did ask the leaseholder for some maintenance. I think there were also some vagrants that may have been in the parking area, and they asked their landlord to get rid of those folks. So, pardon me. So, initially there was a question about, well, they're parking in this area. Should this be compensable? And the Western District focused on the language. The Commission and the ALJ said we don't think it's compensable based on these facts. But when the Western District looked at the case, they focused on that exclusive use language that was in the leasehold agreement. And they also looked at the maintenance and control that the employer exercised over the parking lot. And that was really the key issue in this case. So exercising control, maintaining or having control over the maintenance that will occur in the lot were the key issues in this case.
And I've got a pending case. I've had a couple cases like this where the attorneys, this really comes down to fact-specific information. The questions are, have you done anything? Do you throw any salt out there? Do you have a broom? Do you have things that could possibly be used to control this parking lot area? In this particular case, if I remember, the employees that were parking there were actually sort of cordoned into an area that was somewhat controlled. And so I can see the logic, but it's still a case that you don't know if you want to appeal it, because this is one ripe for the commission to go, no, any sort of control over that property, even if you don't own it, is going to make it a compensable case. So bad for us.
Yeah, definitely.
On the idiopathic side, we have this Gleason case. And if you remember my earlier comments regarding the individual who's up on scaffolding and has a syncope and falls, that case after 2005 we didn't think was compensable because that's a positional risk type of scenario. In this one, and I'll let Sarah kind of run you through this.
So this was a case that the Second Injury Fund actually tried, or they tried to win on this issue.
Yeah, the employer already settled with the claimant, so they were out of the case. So
the ALJ and the LARC, both agreed that the case wasn't compensable. This gentleman couldn't remember how he fell. He failed to provide any evidence or any testimony at trial showing the cause of his fall. That case goes up on appeal to the Western District.
And what's interesting about this, and it may seem like I'm going to be bad-mouthing the commission throughout this, but in this case, the commission didn't find an injury on this one. The commission actually held that the claimant did not meet their burden. So this really stems from the Western District here. Yeah, ALJ and the commission both denied the claim against the fund. He failed to show a cause of the fall. You're doing it wrong.
Next slide. Next one. It's me. So when the Western District heard the case, they said, you know what, this guy doesn't have to show us why he fell. He's working on a rail car 20 to 25 feet above the ground. I think it's probably unusual risk, and he doesn't need to show us how he fell. It doesn't matter that he doesn't remember how he fell. That situation in and of itself is going to be unusual enough that he's not going to encounter that in his non-employment life. Thus, case is going to be compensable.
And again, it's sort of a paring down. I mean, if you look at the result just on its face, you think, oh my gosh, we're moving back to a positional risk type of situation. But more importantly, I think from our standpoint, and again, the employer was out of this case by this time, and no ill will against Second Injury Fund. I don't know that they did a great job.
They're also working, I'm sure, in a situation where they couldn't interview the employer or didn't interview the employer. They were just working off of the paper to establish that defense in the case.
And the fund's logic, much like everybody else, is saying, you're basically allowing the employee to recover for what we all understand to be an idiopathic injury.
If you can't remember why it happened, then
And that was the problem with the case. He had amnesia after it, so it wasn't like you could go back and say, well, why did you fall? I don't know. I don't remember falling.
But
what we need to do, though, now, and what this case has generated is much like a statute of limitations as an affirmative defense. If you have a case that you think is an idiopathic event or a syncope or coughing fit or something unique to that individual, that's something that we're going to need to know, because we're going to have to start filing denials with an affirmative defense to include idiopathic injury. So that's just something, we toss that term around quite a bit, idiopathic injury, but in this particular, after this case, that's something that we're really going to need to be using affirmatively.
And this is a good example, too, of why investigation is so important on the front end. Taking that statement, having your employer, whoever takes those initial statements or reports, to get a detailed history from that person. Because if there's any way to lock that person in initially from the outset, then you avoid issues down the road with them changing their story or saying, well, I don't remember now, I'm not really sure this happened. Well, you told me right after it happened that A, B, and C occurred.
Or a witness that says, hey, I saw him pass out. I mean, that would be helpful too, but memory is fleeting. This is a decision that I do not think is in your materials, and this just came down.
Yeah, this has only been within the last couple weeks, if that.
Right. And this is where things start getting a little more curious and upsetting.
So this is going to go back to our discussion about Viley that we had initially, and that follows in the line of cases with Jomie and with Pope. Jomie was the gal who slipped out of her sandal. Pope is the gentleman who was working for Harley Davidson, was carrying a helmet, walking down the steps. And there were questions in all of those cases about, whether or not these people were exposed to a greater risk in the workplace than they wouldn't have been exposed to it at home.
Well, if you remember a few years back, the Miller decision was an individual that was walking briskly back to his truck, and his knee gave out, or his knee, I forgot the nature of the injury, but it was a knee injury, and that was found to be not compensable. And so, hooray for us, but now we're starting to see these cases kind of come back the other way. Now that we're 10 years removed from 2005, this language, and I'll read just some of the passages from this case out of the Western District. This gentleman here, Mr. Young, was working out in
Boone County.
Boone County, he was out in the field. And here's the language. I mean, you'll understand. He was walking, he twisted his foot or something on a frozen dirt clump. Similarly here, even assuming, arguendo, that Young was exposed to the hazard of slipping on frozen dirt clods in his non-employment life, his injury still arose out of his employment because there is nothing in the record to support a conclusion that he was equally exposed to the hazard of slipping on frozen dirt clods at that particular work site in his non-employment life.
I don't know about you guys, but I keep a mock-up of my office in my home, so I can have a similar space
Yeah,
to
I
my
mean,
workplace around me all of the time. I mean, and this is what this suggests here.
But if this is now this sort of new standard, I mean, it's quite fascinating that, you're going to need to replicate how the injury happened in this person's home. So again, back to my original point, we can't look at these and go, listen, this could have happened at home. And honestly, and I look at this and I don't know who was involved in that case, and I don't know that was a great case to appeal. If somebody, slipped on dirt clods or ice, what we end up with now is this kind of law. And so, I mean, you kind of got to weigh how much bad law you want to make with your set of facts. And, there's some language in here that, because this is the employer's assertion. They assert that Young's injury did not arise out of his employment because he lives on a farm and thus was equally exposed to clods of dirt in his non-employment life. Well, so they lose on that point, but in losing, we have this new language. And, when they say equally exposed to the hazard of slipping on frozen dirt clods at that particular site in his non-employment life, I mean, that really shifts the burden our way, and it makes it quite a bit more difficult. So, so that's the Young case, and again, that just came out, but
We're going to be hearing attorneys citing that for
yeah, we're going to start hearing that one, because
propositions.
this almost kind of, the case itself doesn't speak of positional risk, but the language in the opinion speaks to positional risk. I mean, it was a case that I think 50% of us probably would have accepted. But anyway.
So we're just going to run through this one really quickly. Tanya Huff v. Jones Financial is a case that came down probably about this time last year. And this is important from the perspective, you have a subrogation interest that you want to assert in a case. So in this situation, the court said that any payment from that third-party case is going to be treated as a future installment against compensation. So if we're looking at past medical bills and records, it's not going to apply there, or past medical bills rather. So if you have, a $100,000 third-party settlement that occurred before your workers' compensation case was filed, and you had $100,000 in past medical, you wouldn't be able to offset those two. You can only take it against the permanent partial disability or indemnity that's paid, or any future medical. So that's going forward. So that's just something to keep in mind.
Before we get on to injury trends, there's one more case that kind of goes on to that, what we would previously consider to be idiopathic type cases. As this is in your materials, it's the Randolph County case. And I remember after 2005, when those changes came down, I used to get these phone calls quite a bit. Claimant was working with property cards, which were stored in filing cabinets. Claimant had to squat down and twist to remove a file from a tightly jammed bottom file drawer. As she squatted down and reached to the back of the drawer, she twisted her body. On appeal, employer argued claimant's injury did not arise out of her employment because it came from a hazard to which she was equally exposed in her normal non-employment life. And again, those are those words that I used earlier that don't ring as true as they used to. And I think the better analysis is, what is she doing, and does it have any nexus at all to what she's doing at work? And I think in this case, and this is where the commission is going, and this is what the judges are seeing, that if they see any nexus at all with work, they're going to find it compensable. And I mean, I've got a pending right now where an individual's in an office. It's a tight space. She turns to get something out of a file. There was no disagreement from her original statement through her deposition. She's like, yeah, that's exactly how it happened. She added the one simple nuance that I was doing it quickly. And I did ask her coworker, I said, she tells me she was doing this quickly, and she goes, man, that woman's never done anything quick in her life. However, it does change it just a little bit. And and this goes to commission trends and what the judges are feeling, because if you read some of these commission decisions that are coming down, they're not making any substantive changes to the award. They're changing little things about what the judge wrote. And so they're just kind of needling the judges a little bit. And in this case that I was telling you about with the lady who moved quickly, we mediated it with the judge, and I could tell from the judge's face, she's like, listen, you've got about a 25% chance of winning that here, and you got about a 0% chance of winning it at the commission. And that is from a judge who's probably been beat down a couple times with commission smacking them. So those are considerations that we need to take when we're looking at this, and again, all under this whole Manus thing. So I mean, these are all things that we need to look at and evaluate when we're looking at these cases.
So one thing that Steve and I
again, don't kill the messenger.
Another way to defend this, and one thing that Steve and I talked about when we were preparing for the presentation was that in a lot of these cases where they were looking at equal exposure, they kind of rolled over on medical causation. Said, well, we're not going to dispute that this, whatever they have going on in their knee, probably happened because they tripped on this clump of dirt that's out in this field.
Right. So just because the arising out of it in a course of, the owned and controlled, just because that is sort of getting trimmed back a little bit, don't forget that a lot of times our best defense is medical cause. Well, they said this happened 6 months ago. Now this is just coming up. Well, 6 months ago, what happened between now and then? What else is going on? How much pre-existing do they have?
How many times have you turned at home, pulling a bag of groceries out of your car, and you felt your back pop? Same spot, same movements.
So it's our job to muddy the waters, but to get so hung up on, well, this is an idiopathic event. Well, don't forget about medical cause. I mean, focus there too. I mean, that's another one of our defenses, and that's one of our party tricks in the bag. So, injury trends.
So we'll run through this here really quickly. I think we're running over a little bit.
What's our number?
We're not, okay.
These are some stats that we were able to kind of dig up from the Bureau of Labor Statistics. And this is stuff that you folks are probably seeing.
Got more older folks in the workplace now. They're staying longer. And also, their injuries can be a lot worse than people that are, half to 3/4 their age.
And when I first started doing this, one of the first things, I got a new file, the first thing I looked at was the attorney. Who's, the venue, the attorney. Now one of the first things I'm looking at is their date of birth, because that tells me if Medicare is going to be an issue, if this person's retiring, are they looking for permanent total disability. So the aging workforce is, I think it's a big factor in handling your claims now, definitely.
So frequency of occupational injuries overall just decreases with some of those older workers.
Which is fascinating. I didn't expect that.
I didn't either. But when those folks do have injuries, they're oftentimes more, they're fatal. So that's a consideration. It also takes those older workers longer to recover, and I know that I've had experience with that situation. A gal with a fracture, what could have taken normally 6 to 10 months to heal for them to be back to work. I mean, it was a 2.5 years ordeal by the time it was all said and done.
And the other thing that you see with the aging workforce is that whole flow from, you may have somebody who injures their knee and they're 65 years old, and next thing you know, you're looking at a knee replacement because it flows from the accident, and so you may be looking at moderate permanency, but you're still on the hook for a fairly pricey knee replacement. So those are other things to consider with the aging workforce.
And so this wouldn't be a big surprise, but some of the literature and the studies that we took a look at, told us that the costs are going to be higher. More time, missed time from work, greater disability, and increased medical cost.
That's a good one, too.
You looked at the slide, right?
Yeah.
Okay.
But I've seen that too. I mean, when I have, I tell you, some of my worst cases are older employees with foot injuries. I mean, they're out forever. I mean, it takes forever for them to get back. And you know, it's like, do you have any pre-existing conditions? You know, she's 65, 70 years old. Well, yeah, I've got, you name it.
I've been working in a manual trade my whole life.
Yeah.
Yeah, of course it all hurts. So one of the questions that you, or that we received that you guys asked us is, what sort of injuries are you seeing now? What are the trends? And so you can flip through those, Steve. We're seeing overuse injuries.
Yeah, we're still seeing carpal tunnel, cubital tunnel.
And I know that Dr. Frisella just helped me out in a case. You know, there's a question though, what's it related to? Does this person have some sort of systemic endocrine condition or fibromyalgia? You know, they're having wrist and elbow issues, but there's no objective basis for it.
And for my nickel, it's still the most, it's probably the most overcompensated claim in Missouri. I mean, as far as the nature of the injury, the nature of the treatment, and the amount of settlement dollars that we see in these cases.
We're also seeing, for whatever reason, some repetitive trauma injuries with cervical and lumbar spine, which
is something that we didn't see immediately after 2005, 2006. I mean, that statute tried to really take away those types of injuries, but we're starting to see these crop up again a little bit. And again, is that due to the older workforce? I mean, and then, of course, the knee and the spine injuries with the underlying degenerative issues, so the knee replacements. I tell you, I'm starting to see some records come in, and again, you know, a lot of times we get these files 3-6 months after treatment's happening, and we get a file, and I'm thinking, okay, this person's not represented, and we can get this on a conference docket, and I'll read that last medical note, and it'll say, and it's from the nurse practitioner, and it says, we talked about her ongoing problems, and she may need Synvisc injections sometime down the road. Well, what does that mean? And what's the judge going to do with that? And so you see that, and you just have this sigh, and you're like, okay, well, we got to contact the doctor, and when we contact them, we make sure we do the flow from language and try to get them to clarify these things. But you know, every once in a while, there's that one throwaway sentence that you find in a record that really can potentially derail it or increase your reserves without you even thinking about it.
So these are why these issues are significant for us. Again, pre-existing conditions, medical causation. Does that need for treatment flow from the underlying work injury, or is it related to something?
Is it related to something else? And,
Yeah.
and if you ever have a question, if you ever find yourself at the end of the case and you know you need to find a report from the doctor, kind of wrapping everything up and closing all your loose ends, if you're unsure as to what language you want to use, call somebody at our place. Just call and say, listen, here's the file, it's not there yet, or I want to try to wrap this up. What should I ask the doctor? Because I need it tightened up. And you definitely need it tightened up if you've got surgery on somebody who is Medicare eligible. That is very important because the judges are well aware of people's ages and are well aware of MSAs and are well aware of how this all works. So those are questions that we face when we're trying to resolve these.
And we talked about this earlier, but increased costs are associated with some of these trends. Increased recovery time. Permanent restrictions.
Yeah, and some of that bleeds over into HR issues and whether or not they can go back to work, whether it becomes a retirement issue, and all that kind of stuff, as you all well know, complicates these cases. Oh.
I know, then reasonable probability for future medical, something that we talked about.
And on that issue, there's this case that kind of goes to that future medical, and Sarah will tell you about it.
Yeah, so Pierce is a case, you may have heard about this, or you may have been contacted by counsel with regard to drafting settlement stipulations. So this is kind of the, this is how this case occurred and how this issue was generated. So this claimant had a compensable knee injury, had 2 surgeries. The authorized treating physician concluded that the claimant wouldn't need a knee replacement as a result of this injury, but had underlying pre-existing arthritic issues that would cause a need in the future. Of course, claimant's experts said that they did need a medical or a knee replacement in the future, and that was the opinion, or those were the opinions in that regard. So the parties settle, then things start to disintegrate.
Yeah.
So the way that they drafted the settlement stipulation, and we don't have these facts, we don't know what the reasoning was. I suspect it probably had something to do with Medicare or a conditional payment issue.
It could be that they weren't eligible for Medicare for another year. I mean, there's a couple things that could have factored into how these were drafted.
But the language in the stip read that medical would remain open for a year.
Right.
And during that time, while that medical was still remaining open, or actually it was just a month after the case was settled, the claimant demanded more medical treatment, specifically a total knee replacement, and was ultimately able to
Secure that total knee replacement.
well, we don't know if he's secured it yet, but it's gone back down to the commission for them to make that decision. But they used the reactivation provision under 287-1408.
Which is on the stip, actually.
So that's the provision that talks about prosthesis replacement, reopening, changing condition.
Yeah, on the standard work comp steps, that section's actually on there. It says except as by this section.
So one of the, and I know that there have been folks that have tried to cross out that section in the settlement stipulations. I can, think of one southern region where they will absolutely not allow us to do that, especially, where that person that we're settling with is pro se. But, it creates an issue. So, when we go through, or when we settle a case, there are certain things that we need to make sure that we do now, especially in these cases where there's a possibility that something like this could happen.
Well, that's a whole nother 20 or 30 minutes on that section 287-140.8. I mean, you settle a case and they still have retained hardware, or they got a K-wire in there or something like that. Is that a prosthetic? Is a tooth a prosthetic? So those things all come up, and I know, and she'd mentioned a certain southeastern compensation office that definitely allows the claimants full leeway in expressing their rights.
So now when we're drafting the STIPs, and these are just some considerations that we need to have. If there's any future medical opinion by any physician, opposing counsel's physician, our physician, if we don't have one and it could be an issue in the future, we should make sure that we have that totally locked up so it doesn't create this sort of problem down the road. Not putting any language in there as well that says, leaving medical open for a year unless.
Well, and then you could be very specific as to what you're.
Yeah, for what that purpose is. And let's see, I mean, in lots of these cases, I love attaching an addendum so there's no question about what the party's intent is, what's being offered, if anything, just so you don't find yourself in this sort of situation down the road, or indicating there's absolutely under no circumstances will there be any treatment, will be provided for this specific body part.
Something else on just drafting STIPs, and this is more just of a practice tip. Back when I started, the word hold harmless, we'll just put hold harmless language in that STIP. We'll put hold harmless language in that STIP on the medical, because maybe medical was disputed. I've kind of, and I know most of the folks that I practice with are the same way, we've kind of done a 180 on these hold harmless agreements because, and I've convinced most attorneys on the other side that a hold harmless is not what anybody wants, because the second you put a hold harmless in the STIP, you're basically opening the door up to a provider or a fee dispute or somebody to come back and go, hey, there's a hold harmless in there, I want my money.
We have seen some people come out of the woodwork.
But if you dispute everything, those fee disputes are very difficult. A lot of them just die in a vine then. So instead of, if there is disputed medical out there, we do the complete opposite, and I try to convince the opposing counsel, hey, it's actually in your best interest if we deny this. That way nobody's coming back knocking on your door, nobody's knocking on our door, This was all disputed, and it was unauthorized, and we put unauthorized in that stip 3, 4 different ways.
So with regard to employer control, the way that we're going to weave this, and we're going to talk about a case here in just a moment, but under Missouri law, employer and insurer have the right to direct and control treatment. Employees need to know that they're seeking treatment on their own, that it's unauthorized, and the employer will not be liable for those charges.
We think.
Yeah, maybe.
And this is something that I talk with claimants when I meet at a conference docket. If it's an upset claimant, you just send us to Dr. No, or this is the employer's doctor. I don't know how many times I'm sure you all have heard that. But what they don't realize that it's the employer, insurers, their best interest to send these folks to the best people possible, because if they're off work, that's no good. That doesn't help us. If they get a bad result, that's no good. Why are you sending me all the way to St. Louis? Well, because where you're at, they don't have any doctors. That's why, and it takes a little while, but a lot of them come in so defensive about the possibility of an employer-controlled state. It really, clearly there are cost controls built into that as well, and that's another benefit for us. But, that's something that we hammer in with the claimants.
But Brown and Brown says their doctors often find things that our doctors miss.
Well, I should send my mom to their doctor. Because that's what I always say. I said, listen, these are doctors I send my mom to. And they kind of look at me and they do that dog thing where they tilt their head like they don't, and I go, seriously, these are people that I use. So.
And in the end, using those physicians, we're using those good doctors, we're going to get a smaller overall PVD. What time? 42. So we're just going to run through this really quickly about employer control. So your employer, you're insured, we're still going to maintain control even after the case has been settled. And
this case stems from where the case settled, but treatment was open, and they're still paying benefits. And
PTD award, future medical. So in this case, the employer tried to unilaterally stop payments when the employee wouldn't appear for an IME or an exam. I suspect that they wanted to try and change the course of treatment here. Things had changed with regard to the claimant's condition. So they stopped TTD. The case goes up to the commission. The LARC says, you can't compel this claimant to go to the exam. You can't stop the TTD. Based on this issue. What you need to do is come back to the commission, file a motion for a change in condition.
Right. See, they're making me sick.
Any motion sickness? Yeah. Sorry.
Commission trends, sort of evident from some of the conversation that we've had for the last 45 minutes. It is a claimant-friendly commission. I don't think anybody would argue with me on that. And that is the environment that we're dealing with now. And again, with Manus and Son of Manus, those are things that we just need to deal with in how we're handling our claims. And again, the idea is to maintain exposure, cap exposure, get an idea of what our potential exposure is. Another trend, it's kind of the nanny state with the commission. I mean, the way they're kind of nitpicking some of these decisions.
Coddling employees.
Coddling. There's another real quick case here at the end that we'll get to, but I also want to let you all know, I mean, the commission flat out told the judges on dismissals, if we've got a case that's been dismissed, if for any reason, if the employee makes a phone call to anybody and says, I want my case reinstated, they'll reinstate it. So the dismissals that we used to have for failure to prosecute really just fall on deaf ears. It is the commission's intent to coddle these people and to make sure that their case remains viable as long as possible. We've all had cases here that have been dismissed and been reinstated. It's to the point where the judges aren't dismissing cases because they'll say, why should I dismiss it? It's just going to get reinstated. So if it helps, the judges are as frustrated as we are at times. Because, whatever they do, I had a judge say, why even go to the effort of writing the award when it's just going to get turned around, or it's just going to get altered, or it's just going to get, so. And another commission trend based upon
So this is Hinkle.
this case here, and this case had to do with commutation of a ongoing award. And the commission, and we've had trouble. I've had a couple files come in, and they say, hey, listen, we've been paying benefits on this case for 5 or 10 years. We want to try to commute the award. What can you do? Well, it used to be you would just write to commission, you'd give them all the evidence, and they would say, okay, fine. You'd have to go through a couple hoops, but this commission is real hesitant to offer any sort of commutation on settlements because, at least from our opinion, it's almost like they want to handhold and make sure the claimant doesn't make a bad decision. And so in this case, the commission attempted to argue that it didn't even have authority to commute the settlement. Well, at least the court came back and said, no, you do, and this is how you do it.
So we talked about Sarah and Ben talked about the Bertels decision a little bit earlier. This is a new decision that was just issued by the commission. Not great. And then the next decision, Mantilla v. MoDOT, was actually, it's a mental case. And there was another decision that was issued a few months before this concerning a prosecutor over in the Kansas City, Jackson County area, where they said, you know, this person did not meet the threshold or the statutory requirements for proving a mental. They didn't show that the stress that they were under their situation was more stressful than any other prosecutor working in the office. Although they didn't discount that, you know, working in this trade and working as a public defender or prosecutor is stressful, that person just didn't make an evidentiary showing. Mantilla was a little bit different. This person probably had, they did find eventually that they did have a mental case, but
The facts are pretty
gory.
Pretty gruesome on that one. I mean, I'll save you the details.
Yeah. But what the commission allowed them to do, though, was to make this compensable case without having all of the expert opinions that they needed. So in this case, they didn't have to make that showing, or the commission didn't require them to make that showing or found it compensable without them showing that other MoDOT employees were under similar stresses, or that this person was in a more stressful situation than other MoDOT employees, which could be a bad thing for mental cases in the future.
If you read the facts, you go, oh yeah, that's a mental.
Can you give us an overview?
Well, I've got the.
If you're going to make me. Okay, so
Just read the one part.
let's see here.
Everybody done eating?
Okay, we cannot conclude that the stress employee experienced was anything other than extraordinary and unusual when, in the course of her employment, she listened helplessly to the screams as a child as he burned to death, accidentally kicked an accident victim's decapitated head. Oh, okay, sorry. Accidentally kicked an accident victim's decapitated head, stepped on teeth scattered across an accident scene, breathed air filled with the scent of burning flesh. Do I need to keep going, you guys?
So the point is, that's a
only half
mental
of it,
case.
yeah.
But the way they got there was sort of non-traditional, how they got to the result. I mean,
Yeah.
all of us would probably agree, oh yeah, that's so.
But we would have liked for them to have an expert opinion that would have supported that position. So we hope that we just don't see anything that comes down the pike later that relies on that case.
That's all we have. Does anybody have any questions, any specific facts, anything, any text come through?
Nope, no text.
Nothing.
All right, thanks, guys.
Thank you all. And, I'm sorry. If anybody ever has a scenario on these owner-controlled or idiopathic cases, just call us and we'll kind of bounce